Good morning. A very fantastic judgment, most important for defense lawyer. After a long time, AR 2023 Supreme Court 1487, Premchand versus State of Maharashtra, where accused was convicted for offense punishable under section 302 and 307 because he not only killed the person and also assaulted the other witnesses. So therefore, the lower court convicted him and High Court also confirmed the conviction. But Supreme Court, with elaborate discussion about the evidence, actually what happens, this is accused seems to have opened his shop, and accused as well as PW2 were sitting opposite, and suddenly there was a quarrel. So initially, the accused seems to have assaulted PW2, and thereafter deceased seems to have intervened, and the accused, after going inside his shop, brought a knife and stabbed him. And therefore, the Supreme Court categorically discussed about these incidents, and later on also they have given a wider judgment about the importance of 313. They have also stated that after amendment Cr.P.C 3135 Cr.P.C, it is not between the accused and the court. The amendment says the public prosecutor as well as accused may also assist the court in framing 313 questions. The Supreme Court has stated that the court is not bound to take incriminating evidence alone and the explanation given by the accused. The court should also exculpatory defense of the accused also. They also have stated that the court, when the accused has filed a written statement under 313 Cr.P.C, the court ought to have marked it as an exhibit and consider that about other prosecution case. Here is there. Therefore, after elaborate discussion of this judgment, the Honorable Supreme Court has given two ratios. Number one, that the evidence should be totally appreciated to bring the accused for any particular offense. Here, since the entire incident prosecution comes under 304 Part 2, for the following reasons. They said, I have said AR 2023 Supreme Court 1487. So these all are they say conviction was altered to 304 Part 2 Para 23. You see, kindly, the court has stated that there should be 4 necessary ingredients to apply 304 Part. Number 1, it should be a sudden fight and there was no premeditation. Then it was done in heat of passion and the assailant had not taken any undue advantage. All these things seems to have applied because there was no motive between accused and the deceased, and the prosecution has not established as to why immediately, suddenly the accused assaulted PW2 first. That has been considered. All these things exhibits how the defense lawyers are capable of bringing the home. The accused was convicted under section 304 Part 2 and period already undergone. But however, the defense counsel in SLP, I could not understand or whether there was no finding about that when the 302 is altered to 304 part 2, why 307 was not altered to 308. That discussion was not there, but you keep it in mind that that is also most important. Therefore, see the three things. The other day also I have stated that 313, 314 and 315. All these things are most vital for the defense lawyer to understand. And the other day a question was put to me whether 313 could be framed and asked at any time of the trial. Yes, the section says at any time of the trial the court may ask the accused if a witness speaks something specific, you can simply put the accused, what do you say about this? This way they can do it. That's what I understand. So now you can, if you are giving any documents or written statement under 313, that should be marked as exhibit. So this is most important. Premchand versus State of Maharashtra. They have discussed about the earlier Supreme Court judgment also, wherein State of UP versus Lakshmi. They have eventually and extensively discussed about 313 Cr.P.C. And you go through the history of the case with the judgment. Therefore, you can easily understand how the Supreme Court has appreciated the evidence. Uh, uh, they say accused cannot be dissected to rely on the inculpatory part and ignore the exculpatory part, and it should be read in whole. That's what they say. Uh, Thereafter, one more thing I have to know: no electricity. Therefore, the most important thing was that the after reappreciating the entire evidence, Supreme Court has come to conclusion that this was not a case of 302, no premeditation. It was a sudden fight, etc., etc. So kindly keep this judgment on file and record. And about other things, uh, recently, Honorable Chief Justice has privileged us, granted and waived that we need not wear a robe. It's all right, that was a very good thing. And actually, it is not practically possible to wear a robe during this hot summer. That is specifically this year, summer is heavily causing much trouble. And yesterday, some uh, particle from the other galaxy passed through in our galaxy near our Earth. I do not know what had happened to that. That was not communicated to us. Then the most important thing was that our advocates indulging in strike was periodically warned by the Supreme Court. This time also, the courts and High Courts and Supreme Court is periodically warning. And one advocate who could not get through bar examination, eligibility bar exam, approached the Honorable Supreme Court for declaration of the result, and everybody was thinking that probably today the result would have been announced. Let us wait and see. See these things, why they are not concentrating, how this, and this is only 2 months delay, and I understand subsequently the examination for next batch is called for. I do not know about that. If that would be the case, results should be immediately at least 15 days, 1 month time before the next session of examination be announced. Best wishes.